Welcome back to the news wrap. The Justice Department is leveling accusations of racial discrimination against Yale University. A Justice Department investigation found that Yale rejected Asian American and white applicants it would otherwise accept based solely on their race. The two-year investigation comes after complaints by students against Yale, Brown, and Dartmouth. Joining me now to discuss is David M. Schwartz, attorney and partner at Gerstman, Schwartz, LLP. David, great to have you with us here today. An escalating story here. The lawsuit alleges that Yale is discriminatory in the way it accepts students. Is there evidence at this point to support that accusation?
Well, there may be evidence. Okay, so there's a strict scrutiny standard, and the bottom line is you cannot have quotas. You cannot base your admissions decisions on the basis of race. It can be one of many factors, and Yale is arguing that it's one of many factors that goes into the decision-making process when deciding which students to take. But then on the other side of the coin is the Asian students are claiming that they're being discriminated against because there is an unofficial quota system in place.
So I want you to, I think there's a little bit of confusion generally on what is allowed and what is not allowed based on past Supreme Court decisions. The Supreme Court has upheld affirmative action as a constitutional way to set guidelines for how universities can kind of create their admissions process. So is the question here that Yale use that as a determining factor and not as just one small factor? What is the actual core of the argument here?
Right. The core of the argument, and this is a fact-based argument, but certainly you cannot make an admissions decision based on race alone, and it can't be based on having a certain quota in your quest for diversity. So you have this standard, and is it a violation of the Equal Protection Clause whereby Asian students ended up getting discriminated against because of a particular quota that had to be met? And it's a fact-based decision. So Yale is going to argue absolutely not. We did not use race as the only decision-making factor. And the Justice Department, which provides for funding for Yale University, certainly has an interest in this. They're arguing that it's really a quota system that's in place. And it's all a fact-based argument based on the evidence brought in a court of law.
Yeah, to that point, Yale has provided evidence over the past few years or actual data on their admissions over the last few years to the Justice Department. The Yale president said that the Justice Department's accusations are baseless. So how does the Justice Department go about proving the intent for Yale, given the hard data? Were they trying to fill a quota or just using it as one variable? What is the process here for the Justice Department?
Yeah, there's a lot of factors in play, but Yale needs to show that there was a compelling interest. So, and a compelling interest, certainly they have a compelling interest by making sure they have a diverse student population. So there is a compelling interest to achieve that goal. However, their process has to be narrowly tailored. Under the Supreme Court decisions, it has to be a narrowly tailored process in order to achieve that goal. And the question becomes, was this process a narrow process where they weren't using race as the main factor in determining admissions, and that would adversely affect the Asian students who were adversely affected by an African American student taking that spot? So you cannot have a quota system, but certainly race could play a role as to many other factors. And again, it's a fact-based analysis, but it has to be a narrowly tailored policy in order to achieve that goal.
Yeah, and David, at a similar with a similar lawsuit at Harvard, Asian American students who had took the stand were kind of talking about the idea that it's hard to have race-blind applications in that their race, where they come from, their background is so critical and central to their application, to their story. So if the DOJ does find wrongdoing by these universities, what could be the outcome and maybe the application of what needs to change or they want to change at these universities?
Well, I mean, certainly they could try to withhold federal funding for violating that policy, but that's going to end up the way the Harvard case ended up in court. This would end up in court as well. And again, it would be a fact-based, the Justice Department has its position that this is really an illegal quota. It's a smokescreen. You may have, many different factors, 100 different statistical points of analysis when evaluating these applications, but really it's a smokescreen that's going on. That's the Justice Department's argument, that you really have a quota system in place. And it's going to be up to a federal district judge to decide whether or not there was a quota system in place, or whether or not race was one of 100 factors like Yale argues. So it's all going to come down, and I suspect we're going to see this case go to court.
All right, David, thank you so much for your time and your insight here. That's attorney David M. Schwartz. Thanks again.